Yeah.
Yeah, okay. Ma'am, we are live. We are live, ma'am.
Yes, please start.
Good afternoon, everyone. Honorable Advocate Gayatri Singh, Madam, our chief guest for the said event, our respected Dean and in-charge Principal, Dr. Ujjwala Bindale, Madam, learned faculty members, friends from the student community, and all those joining us through the digital space. We, on behalf of the Bharati Vidyapeeth deemed to be University New Law College, Pune's Society for Advanced Research and Analysis on Labor Laws, S.A.R.A.L.L, welcome you to yet another enthralling session on the topic recent amendments in labor laws. Before we proceed, may I request our dynamic and visionary Dean and in-charge Principal, Dr. Ujjwala Bindale, Madam, to kindly grace this occasion with few words.
Thank you, Yash. Good afternoon, everyone. I, on behalf of Bharati Vidyapeeth, deemed to be University Pune, welcome Advocate Gayatri Singh, Senior Advocate, Bombay High Court, a versatile personality of law fraternity. Welcome, Madam. Madam, I'm here to formally introduce you to Bharati Vidyapeeth. Madam, the institutions of Bharati Vidyapeeth were accorded Deemed University status in 1996 for its academic excellence. Bharati Vidyapeeth, deemed to be university, has established academic excellence and offers programs in innovative and emerging areas. It is multi-campus, multidisciplinary, and is catering to the needs of urban and rural students. It has world-class infrastructure and facilities, has launched several innovative academic programs, and has best teaching learning processes, and has entered into national as well as international collaborations. Madam, all this has been possible because of Honorable Dr. Patangrao Kadam Saheb, founder Bharati Vidyapeeth deemed to be university, a visionary who, at the age of 20 years, decided to establish Bharati Vidyapeeth as a distinct educational institution. Today, Dr. Patangrao Kadam Saheb is a guiding star for whole of Bharati Vidyapeeth fraternity. The second patron and pillar of Bharati Vidyapeeth is Professor Dr. Shivaji Rao Kadam Sir, Chancellor Bharati Vidyapeeth deemed to be university, member UGC, member NAC, and recently, on 6th of May 2021, Sir is awarded with Excellent Contribution to Education Sector Award by CMAI, ICT Association of India, and Electronics World Communications Award 2021. Following him, the third patron, pillar, and soul of Bharati Vidyapeeth is Dr. Vishwajit Kadam Sir, Pro Vice Chancellor Bharati Vidyapeeth, member AICTE, and Honorable State Minister, Social Justice and Special Assistance Department. Sir is an excellent visionary like Saheb and is stepping on the same path of success and very positively is carrying forward the torch of Bharati Vidyapeeth to more greater heights. Supporting Dr. Vishwajit Kadam Sir is Professor Dr. Manik Rao Salunke Sir, the Vice Chancellor Bharati Vidyapeeth deemed to be university, who is a disciplinary and a brilliant administrator. Today, under the excellent guidance of our visionaries and patrons, New Law College, Bharati Vidyapeeth has been consistently ranked amongst top law institutes of India by Career 360, The Week, Lawyers Collective, India Today, Education Post, and Outlook. New Law College has been re-accredited with A+ grade by NAC and has also received Gold Star Award from BCI on the eve of its Golden Jubilee celebrations. The best practices we follow at our institutions are international collaborations, innovative interdisciplinary programs, international placements, clinical legal education, social justice through free legal aid, finishing school, student-centric learning, and so on. And to keep up with our academic excellence, today's webinar has been organized by S.A.R.A.L.L, the Society for Advanced Research and Analysis of Labor Laws by New Law College, Pune, coordinated by Dr. Jayashree Khandare Madam, Rahi Alak Madam, and Aniruddha Joshi Sir. Madam, the core goals of S.A.R.A.L.L is to create a collaborative learning atmosphere that will adapt to the changing concept of labor laws, and to strengthen and enhance the teaching and research of labor code by conducting different lecture series, encouraging students to write articles and blogs. S.A.R.A.L.L also aims to provide a dynamic and collaborative learning space, both physically and virtually, to learn more about labor laws. Madam, with all your wishes and blessings, I'm sure S.A.R.A.L will prosper and fulfill all its goals. Once again, I wholeheartedly welcome you, Madam, and express my gratitude towards you for consenting to enlighten our students. Thank you very much for your patience listening. Over to you, Yash.
Thank you very much, ma'am, for your kind words. Now, recent amendments leading to downsizing of various labor laws into 4 specific codes has been pitched as a game changer for the Indian economy and has also been one of the foremost agendas of the incumbent government. This shift, however, while invoking a great degree of expectations, has also evoked certain apprehensions regarding its overall impact on our political economy. To know more on its dimensions and depths, we are blessed to have been joined by none other than the great senior advocate, Gayatri Singh Madam, a powerful speaker and a masterful orator and a true polymath. Madam has had the distinction of completing her undergraduate studies in science on a full scholarship at Wharton School, Philadelphia, USA. Ma'am completed her LLB from the GLC, Mumbai. Post Madam's enrollment in the bar in 1984, Madam's practice extended to matters in labor courts, industrial tribunals, family courts, central administrative tribunal, the National Green Tribunal, and others. Madam continues to practice in the Bombay High Court for the past 15 years. Along with this, Madam has equally been associated with various institutes like the Tata Institute of Social Sciences, where she selflessly continues to groom the future advocates and lawyers of this country. As a mark of her nobility, Madam has empathetically taken up the issues that impact the poor and underprivileged sections of the society and has also been instrumental in suggesting amendments to rape laws. Madam, we are blessed to have you with us today. May we request you to kindly address this gathering.
Good afternoon, everyone. That's a lot of not deserved praises that you have given. I would actually, it's a vast topic. I think I have 45 minutes, right? How much time do I have? 45 minutes. So I would actually, before going into the 4 codes, I would like to put it in the context of an historical background, which is, as far as labor laws are concerned, they have to be understood in a historical context because they have changed from time to time, and they have been made, the earlier laws were applicable to a particular section of workers, and there were many problems which we need not go into right now. As far as enforceability is concerned and as far as the applicability of the laws are concerned, because it applied to a very few section of workers. And the third aspect as far as those laws were concerned was that it basically also tried to limit the role of the trade unions by bringing in the state as the intermediary between the employer and the employees. These were some of the weaknesses, and really they came into being because of earlier. If we look into the history of the 1800s and early 1900s, we find that there were no laws protecting workers. They were basically based on the rule of whoever was powerful, and with regard to the rights of the workers were basically determined on the basis of contracts which were signed. And as we all know, contracts are signed between two equal parties, but in this case, it was basically between two unequals. So many of the issues relating to their working hours, etc., were never really considered and dealt with. It was only during the period of the World Wars I and II that the industry needed workers, and they needed the workers to be disciplined, and they needed safe working conditions, that certain laws came into existence. And if we look at from 1920s to at least the 1940s, we find that the major chunk of the laws came into being during that time. They were Payment of Wages Act, Industrial Disputes Act, Factories Act, and various other sectorial acts relating to dock workers, mine workers, etc. So now, leaving that aside, as far as those innumerable laws that that were passed during different times, these labor laws and the working class were basically also, we should also look into the fact that the rights of the workers were determined by judge-made laws. And a lot of the rights of the workers really came out of those judgments. So if we look at the judgments for the period from 1950s to 1980s, we find that a large number of judgments were with regard to the rights of workers, and particularly the unorganized workers. If you look at the Asiatic case, etc., etc. Soon after that, from the 1990s, the trend completely changed, and a lot of cases came up where basically the earlier laws were rewritten and revised, and the rights of the workers were basically eroded subsequently. So now, as that background, we look at the four codes. I really don't want to go into too much of detail into each aspect of the four codes, but I would like to just cover the main issues that are problematic. I am not really going to go into the positive aspects, because we really don't know how far it has right now. How will it be impacted? How will it be implemented? So the reservations that most people have, I would like to focus on that. If we look at the first code, that is the code on wages, which was in 2019 and which was subsequently notified in 2020, we find that the code on wages covers 4 acts. Basically, there are Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act. I would just very quickly go through the Minimum Wages Act, because that was the most important act, and also the most neglected, I would say, the most unenforced act out of all these acts. If we look at the Minimum Wages Act of 1948, we find that the Minimum Wages Act actually from 1948 till present was really ineffective. It did not, though it sought to fix minimum wages, it was fixed only for particular industries, for scheduled industries. And even those rates were far below the poverty level. And even those rates were determined by a committee which sat together and decided on the rates. They never got back to the workers or got any opinions and hearings on the suggestions that they made. And it was, whatever rates that were fixed were basically fixed for long periods of time. Maybe they would be, though they were supposed to be revised every 5 years, they were never revised. So it was after this Minimum Wages Act, when these deficiencies were realized, that number of committees were set up. And I would just like to focus on those 2-3 committees, because they are very important in giving us some guidance as to how minimum wages are to be fixed. One of the committees was the 15th Indian Labour Conference, which in 1957 set out certain standards for deciding minimum wages. What should be the standard, or what should be the basis for deciding how minimum wages are to be fixed? They basically said that there were 5 norms. One norm was that they should consider a family with 3 units. So you have 2 adults and 2 children. then the calorie limit or the minimum limit of calories which a family should have would be 2,700 calories. It should include the cost for clothing. It should include the cost for house rent allowance. And out of the total minimum wages, 20% of it should be reserved for fuel, lighting, and other miscellaneous expenses. So the components of the minimum wages should include the food basket, clothing, house rent allowance, and fuel, lighting, and other expenses. This itself was ineffective because ultimately the rates that were fixed on the basic wages, which were not related to the cost of living index. So ultimately in 1988, the Labor Ministry's conference took a decision that the minimum wages should be linked to the CPI. And ultimately in 1992, the Supreme Court in the case of Rapid Bread said that in addition to what the ILC has set out as far as the components of minimum wages are, in addition to that, it should not only be based on the bare minimum of sustenance, but it should be, in addition to that, there should be components for children's education, medical requirements, minimum recreation, contingencies like old age and marriage, and these should constitute 25% of the minimum wages. So if you look into the background of all these committees, we find that all these committees said that the basis on which minimum wages was being fixed at the poverty level, which was a wrong calculation, and that certain other factors and components should be taken into consideration. It is not only the food basket, but it is also expenses relating to education, house rent allowance, etc., etc. These all, in addition, should form the basis of the minimum wages. Despite this, there was no improvement in terms of wages which were being paid to the different sectors, which were basically the lowest of the low sectors. The National Commission on Rural Labor suggested that there should be a floor level minimum wage. Now, this is very important to understand because if we look at the wages code, it deals with the floor level minimum wage. What is the concept of a floor level minimum wage has been set out by all these various committees which I have said, and there are many other committees which I don't want to take time on going into that. But the 1991 committee basically said that the wages of the rural workers is far below the poverty line, and therefore there should be a national minimum wage, and that they fixed at rupees 20 per day. That was the rate that was fixed in 1990, and that was subsequently revised in 1996, and now gradually scaled up to 176 per day. So today the minimum wage is 176 per day, which is not even even if we look at all the additional components, it does not take into consideration all these aspects. And it is for this reason that the central government set up another committee, which is known as a Satpathy Committee in 2018. Now, before I go into the Satpathy Committee, I just want to deal with three aspects of the minimum wages code. Section 9 of the minimum wages code says that the central government will fix the floor wage, which is the minimum living standard for the workers. So the central government will be responsible for fixing the minimum floor wage. Now, once it fixes that, then the state governments can fix their own rates depending on what the minimum floor wage is, and their rates cannot be below the national level. It should be either higher or at the same rate. The state governments will decide on these, will fix the minimum wages based on what the committee recommended, their local committee, etc., etc. I don't want to go into how it is calculated, but basically Section 6 and Section 9 are important because Section 9 gives the powers to the central government. Section 6 is the powers which are Section 8 is a section which gives powers to the state government. The Now, since there was no minimum wage fixed, no national minimum floor level fixed, the central government, as I said, set up this Satpati committee. The Satpati committee went into great detail, and again, I don't want to go into it, but I think everyone who is interested in labor law and minimum wages should read that report, because it basically summarizes all what I have said with regard to the committees that were set up, how they evolved the minimum floor wage, and subsequently what is the present situation. The committee came up with several recommendations. One recommendation was that it is not only the calories that should be counted, but in addition to calories, proteins and fats should also be included in the food basket. The second suggestion was that the units, the family unit, should be increased from 3 to 3.6. And the third recommendation was that essential non-food items like clothing, fuel, light, house rent, education, medical expenses, footwear, and transport should also be included. So basically, it took into consideration the recommendations of the ILC as well as the recommendation of the Supreme Court judgment. The directions of the Supreme Court judgment. So the final recommendations with regard to what should be the minimum floor wage, the national minimum wage, they recommended that it should be 375. And as I told you, right now at present, it is 176. It has now been suggested that it should be 375 per day, which would come to 9,750 per month. This is also, though many people have said, particularly employers have said this is a high amount, many of the unions as well as workers working at that level have said that this is the bare minimum. In fact, it is not it's not even at the level of sustenance. It is much below that, and it would fall about the same as a poverty level. The additional recommendation was that there should be revision in those minimum wages every 5 years. But since the wages are not stagnant, they are related to the cost of living index. Their wages would accordingly increase according to the cost of living index. So these are basically the recommendations. However, and these recommendations were given in January 2019. This was much before the code was notified. The code was notified in December 2020. However, these recommendations, which are based on recommendations of experts and on evidence and on several documents, have not even been considered by the central government. They have not even said why the report is right or wrong. No opinion or decision has been given with regard to the report. And instead, surprisingly, the government appointed another committee on 3rd June 2021, which is known as the Mishra Committee. That committee basically is supposed to go into the same issues. So the same issues which for over 1 year this committee was working on, the Mishra Committee will go into those issues relating to how the minimum wages are to be fixed at the national level. And that committee has been given a period of 3 years to complete its report. So just to conclude our discussion on this, that the minimum wage code is in fact totally ineffective, because the main provisions of the Minimum Wages Act, and which are included in the code, have become totally non-implementable, because there is no national minimum wage yet fixed, even though the committee had made those recommendations. The second part of that wage code is the Equal Remuneration Act. If we look at the code, we will find that there is only one section, that is section 3, which deals with the issue of equality for both men and women. So the issue relating to equal wages and equal pay for women as compared to men doing similar work is occupied by one section, but the remaining provisions of the Equal Remuneration Act, which basically provided for a mechanism by which the act could be implemented. None of those mechanisms or enforcement provisions have been included in the code. So we find it absolutely a sort of a tiger without any teeth, because not there, except for saying that they are entitled to equal wages. How are we going to enforce it? No provisions have been provided. And then finally, we come to the issue of wage deductions, payment of wages. Now, the Payment of Wages Act basically provides for a number of provisions, but the basic problems with the provisions which are included here are twofold. One is that the wages are allowed to be deducted based on the performance of workers. So if, say, for example, there is some dispute between the management and the workers with regard to productivity, and they do not perform or give that production, then their wages can be deducted. And there is no provision with regard to how the workers can raise a dispute or can get their dispute settled through any mechanism in the act itself. The management can on its own decide to deduct the wages. And two, and this is very important because there have been a number of judgments on cases relating to wage deduction. And I don't want to go into it, but one very important judgment is the case of the State Bank of India, where the workers, where the officers, actually employees, had protested regarding certain unfair practices. The management just arbitrarily decided to deduct wages, even though they had just gone out and protested during their lunchtime, came back and started work. However, for the full 4 days or 5 days, entire wages were deducted. And the workers said that this was totally illegal because they were not given any hearing, nor were they allowed to present their case. And without deciding on the issue, they had arbitrarily decided to deduct the wages. And the Supreme Court held that this was illegal. It could not be done without first hearing the workers. So here again, provision has been added by totally doing away with the decision of the Supreme Court. The second aspect of the Payment of Wages Act is that it allows recovery of advances. Now, if everyone remembers the Bandhua Mukti Morcha case, that case pertained to bonded laborers, and the Supreme Court had said that any form of advance which is given to the workers, that advance itself is presumption of the fact that there is bonded labor. So the giving of advance itself is a presumption in favor of that, and the workers don't have to prove that they were advances were taken from the employer. It is the employer who has to say that no, this advance was not given. Now that through the back door, a provision has been entered in the Payment of Wages Act, which says that advances can be recovered. Again, this is contrary to the Bandhua Mukti case and does away with all the positive judgments with regard to that. Yes, so in addition to that, there is also a provision with regard to overtime, and it basically delegates states to fix the hours of work for a normal working day. So earlier, if it was an 8-hour working day, you could not work extra beyond that. And if you were made to work beyond 8 hours, you were to be paid overtime. This provision in the Act really does away with the benefit of getting overtime payment, because it basically says that the state government has the power to decide what is a normal working day. We'll come to the normal working day under the occupational health and safety, but basically this is with regard to the deduction of wages. Now, I've very, very quickly dealt with it. And then the third final act is the Bonus Act. The Bonus Act is very important because under the Bonus Act, employees were entitled to 8.5% bonus, irrespective of whether the company got profit. Now, under this act, after 5 years, if the company earns any profit, then there is a provision under the act which says that the employer can set off or set on any additional expenses or income with regard to determining how that surplus is to be calculated. So without setting out any criteria or a benchmark with regard to what are the items which should be set off and set on when determining surplus, the provision basically says the employer can do that. And this is one way of avoiding payment of additional bonus after 5 years, which workers were entitled to under the Payment of Bonus Act. If the management was earning profit, they could go to court, they could ask for production of documents, they could go into the balance sheet of the company. Now here, there's a specific provision which says that employers can do that without allowing workers to go through their entire records. Finally, we come to the issue. Actually, I'm still on the first code. The second code, I'll very, very quickly go through it. That is the Industrial Relations Code of 2020. It deals with 3 acts, the Trade Union Act, the Industrial Employment Standing Orders Act, and the ID Act. Now, the ID Act, I would like to first deal with that because that was a very important act with regard to several issues. The first issue was settlement of disputes through the conciliation process, and where the state takes the intermediary role between the employer and the employee. Conciliation proceedings form a very important part of the ID Act. The problem with conciliation proceedings, when we look at the enforcement of that ID Act, is that the conciliation proceedings basically drag on for many years. The employer takes advantage of the situation. There are no powers given to the conciliation officer to expedite the matter. He can drag on the matter till finally the workers are exhausted. And ultimately, after many years, the matter, because the workers on their own cannot approach the court, they have to go through the conciliation process. So ultimately, once the conciliation officer decides that the dispute cannot be settled, then he makes a failure report to the state government. And the state government then refers it to the industrial tribunal. So this is a long drawn out procedure where years are spent in this entire procedure and ultimately the workers get nothing. So the government should have sought improvement of those provisions to ensure that speedy justice is got as far as the workers are concerned. But instead of doing that, they have added additional provisions with regard to the conciliation proceedings. More conciliatory provisions have been added in the Industrial Relations Code. And I just want to deal with that because it's a very sad situation where the workers will be even more handicapped because the whole procedure will take even more longer for it to be solved. So the first committee, in the earlier act, you had to make a complaint to the management and then a copy of it to the conciliation officer. And the conciliation officer would call the parties for discussion and then proceed accordingly. Now in this act, they have added a section which says that in every establishment having 20 or more workers, if there are 20 or more workers, then you must have a grievance redressal committee. Now that grievance redressal committee will consist of employers and employees equal number, and a worker who has a dispute against the management has to make an application to this grievance redressal committee. The grievance redressal committee will consider that application, and within 30 days they must give an opinion on that. If they do not give an opinion on that, then the workman can go to the conciliation officer. So this is the first additional step which has been added before going to the conciliation officer. So first you have to go through the grievance redressal, then you go through the conciliation proceedings. Then if the conciliation proceedings do not, now they've added another provision which was there, which was amended, the ID Act was amended, which said that if the conciliation proceedings take more than 45 days, then a worker can directly approach the court. So that provision is retained. But the point is that you again go through this lengthy procedure and finally, ultimately, you end up in court, which is again where the matter can drag on again for many years. So instead of making the provisions tighter and more easily accessible, with speedy justice being given to workers, it is being made even more difficult. The addition to the Industrial Relations Code is on the definition part. There are a number of definitions included in this code, but the most important is the fixed term employment. Under this code, which is also added in other codes, the word fixed term employment means that a worker can be appointed on a fixed term for a specific period of time. Now, this is an additional branch of the labor, where earlier you had temporary workers, casual workers, temporary workers, and permanent workers. Now there is an addition to that, which is fixed term workers. So basically, even workers who could be employed on permanent posts will now be employed on a fixed term employment for a fixed period of time, where they will be denied all the benefits like PF, etc. And even if they get PF, it will be for that 1 year period or 2 year period. It will not be for, and ultimately a new fresh person will be appointed, and so on and so forth. So this is a new term which impacts the workers. And finally, if we come to the issue relating to the trade unions, because that the second act is the Trade Union Act, which has been included, is the issue relating to registration. Earlier, there was a provision where any 7 workers could apply for registration. Now, and there has been an amendment to the Trade Union Act also, which adds this, which says that at least 10% of the workers or 100 workers, whichever is less, should be members of the union if the union has to be registered. So now you have to show 10% of the members of that particular industry as members of your union if the union is to be registered. The problem with this is, it's not a question like many people have said that this is supporting multi-unions, etc. It's not a question of multi-unions. It's a question of a worker's right to form any union that he or she wants. And there should be no restriction. Like, for example, even for employers association, there are a number of associations formed by the employers under different names. There's no restriction on that. Why should there be a restriction on workers forming their unions, where, even if it means that a particular number of workers will support one union and another particular workers might support another union? There should be no intervention from the state in deciding which unions or how many unions workers should form. That is one. Secondly, the second part of that provision in the code is section 14, which talks about negotiating union or a negotiating council. This is very important because earlier there was no concept of a recognized union. If you wanted to get a recognized union, you had to go to court and get an order, particularly in Maharashtra. We have the MRTU and QLP Act. You have to go to court, get an order of recognition, and you have to show that you have so many workers as members. Here, the employer on his own can decide who the negotiating union will be, particularly if there's only one union. So if in an industry or in a factory, there's only one union among, say, 100 workers, and there's only a certain number of workers who are members of that union will form the negotiating union, and that union will be recognized. So you don't even have to go to court or seek the election of the workers. The unions had suggested that there should be election, like we have election for the assembly and for general elections. There should be elections for workers also, which union they want them to be represented by. That has been given a go by, and this concept of negotiating union has been introduced. And the second part is, if suppose there is no union at all in the company, then if there are 51% of the 51% of the workers are members of a particular union, then the management should have to include that union. And suppose there are no 51% supporting a particular union, then it would be 20%. So suppose there are 4 unions with 20% support, all 4 would be on the negotiating table. But again, as I said, this is problematic because you really don't know how many workers are supporting which union, and which union really has a genuine support of the workers. So this issue regarding recognition is problematic. And finally, on the issue of standing orders, I will try to finish in 5 more minutes. Standing orders. The standing orders is basically an order which provides for the rights of workers relating to permanency. So you have different categories of workers under standing orders. You have temporary, contract, badli, apprentice, and permanent. And each one is given a particular right under the standing orders, which the managements have to comply with. Now, that standing order was applicable for any industry where there were 50 or more workers. That number has been increased to 300 and more. So basically, what it means is that in the smaller factories, which is more problematic, there would be no standing orders applicable, and it is only for factories where there are 300 or more. Now, finally, coming to the two last codes. One is the Social Security Code of 2020, that does away with 10 acts. Now, that is very important because the Social Security Code was introduced. Basically, there were suggestions from various unions as well as other people saying that there should be universalization of Social Security, which is to say that Social Security should be available to everyone, even those who are organized workers and those who are unorganized workers. So we had the Social Security Act in 2006, which basically tried to protect the unorganized workers, who included self-help workers, house-based workers, and workers in unorganized sector, which basically meant where there were less than 10 workers employed by an industry. That was an unorganized sector, and BD workers. That now these 10 acts are basically done away with. So the Unorganized Workers Act, the Building Construction Workers Act, the Payment of Gratuity Act, Maternity Benefit Act, EPF, ESI, Compensation Act, all these acts have been done away with. Now, my problem with this is this, and I'll just deal with it and will not go into much detail, is that if you're doing away with particular acts, then you should say that it should be made applicable to everyone. But instead, what the code does is, it sets out a schedule in the code, and it says that this code will be applicable to so-and-so persons. So basically, it reintroduces the category of the classification with regard to number of workers to whom it will be applicable to. So say, for example, the Provident Fund Act is applicable to 20 or more people. Again, that number of workers is retained in the code. ESI is applicable to 10 or more workers. Gratuity and Maternity Benefits Act is applicable to those workers in a factory or in a shop. Now, under the Act, the factory would be that which has 10 workers where there is aid, where there is manufacturing activity with the help of aid, or 20 workers where there is no aid available, power available. So here you have all these classification, and so what the Social Security Code does is it sets up 4 different boards. One board is the PF board. The second is the ESI Corporation. The third is the Social Security Organization. It's called the National Social Security Board, which will basically devise schemes for the unorganized sector. And the last one is the Building and Other Constructions Welfare Board, which will set up separate schemes for the construction workers. Now, these are 4 separate schemes, and the code basically deals at great length what are their rights and so forth. But ultimately, it gives the power to the central government to frame these schemes, and with delegated power to the state government. So ultimately, the Act code, if you look at it, there is no specific provisions with regard to how this Act code is going to be implemented with regard to which workers, which workers are going to get the benefit, what are the schemes. All this is left for the central and state government to devise schemes separately and notify them separately. So ultimately, it is an empty shell with regard to the rights of the workers. And I don't want to go into all the details with regard to what the PF fund does and the ESI fund. But basically, with regard to the ESI fund, it also encourages private sector. So where the ESI has a large amount of funds available with it, instead of utilizing those funds for the workers and for the medical treatment and other treatments of workers and their families, the government has now, both the state and the central government have now entered into private agreements with private hospitals which will provide medical help or medical treatment to workers on the ground, that ESI hospitals do not have those facilities. So instead of improving the facilities of those hospitals, you are actually going out and giving the money and funds which you have generated for years here to the private companies in setting it up. And finally, I will just go into the last code, that is the Occupational Safety, Health and Working Conditions Code of 2020. Now, two important points with regard to that is, as far as occupational safety health is concerned, there were several acts. There are about 15 acts which have been repealed. 13 acts which have been repealed. Now, the most important acts which dealt with safety, health and safety, as well as the sectorial provisions relating to health and safety were Factories Act, Plantation Labor Act, Mines Act, the Dock Workers Act, and the Building and Construction Workers Act. If you look at the provisions relating to health and safety in the code, there's absolutely nothing with regard to how you're going to monitor and enforce the provisions of health and safety under the code. There is no monitoring agency. There is no enforcement agency. The only enforcement agency that is included is the inspector cum facilitators under the Act. Now, these Act, earlier under the various acts, the inspectors were given some amount of freedom to decide to inspect factories. Now that freedom has been completely taken away, and it is up to the central government to decide how the inspection is going to be carried out. And if it is if the industry is in the state government, is in a particular state, then the appropriate government will decide whether to go and inspect, whether it needs to be done. So say, for example, if you all must have heard about the Pune accident where 17 workers were killed. There was an explosion in a factory, I forget the name, but there was an explosion, a chemical factory, and 17 workers died. There's a report being prepared by various people. They found that the factory did not even have a factory license. No inspector had visited the factory since the time it was set up. The PF and ESI provisions of the Act were not being complied with. No worker was covered, and out of the 15 workers who died, only 12 workers were covered under the ESI. What it means is that the workers will not get their benefits under the ESI, nor will their family members get the benefit under the PF, because they were not covered, even though there were more than 100 workers in the factory. So you had the factory inspector, even under the existing acts, did not go and inspect. So what can we expect under this new code, where there is absolutely no provision for inspection? All that they have to do is the facilitator, whatever they're called, the inspector cum facilitator, are supposed to ask the employer to put all information on the website. They look up at the website, they verify, and they do a randomized survey of the factory. That randomized survey is decided by the appropriate government, that is the state government. It'll decide, okay, so-and-so person needs to go and inspect so-and-so factory at so-and-so place. But suppose there is a factory in Pune and immediate action needs to be taken. They have to wait till they get the permission from the Bombay office, which is the state office. So in major cities like Thane or Pune or any major metropolitan metropolitan cities, you have to wait for an inspector to go and inspect till you get directions from the state government. So it's a very sad situation, because health and safety is one of the most crucial aspects of any labor legislation. And unfortunately, there are absolutely no provisions with regard to ensuring that the factories are properly are safe and healthy. And finally, there are many provisions, but the most important problem with this provision relating to working hours. The central government has given the state the power, the delegation to decide what would be the normal working day. So say, for example, though the code says that there should be an 8-hour working day, that 8-hour working day can be exempted under certain conditions, and the state has the power, because labor laws is a concurrent subject, and states have the power to decide their own acts pertaining to their peculiar conditions. So working hours and annual leave and rest periods are all left to the appropriate government to decide what should be. And that is why in Rajasthan, Madhya Pradesh, and many states have introduced provisions with regard to working hours being more than 8 hours. Many of the states have introduced 12-hour working day without any rest and without any overtime. I'll just conclude here. So sorry for taking so long.
Brilliant, brilliant, absolutely brilliant. Madam, let me say this with all the belief and conviction at my disposal, that the purpose behind organizing such web meets by S.A.R.A.L.L seems to be best served by ingenious speakers like you, who with their depth of knowledge simplify the most complicated things and present them in their own unique and extraordinary ways. Madam, as we know that this particular session is being streamed live across all the social media platforms, we have got plenty of questions dealing with the exposition which you've just given. With your permission, madam, if we could just proceed with a quick Q&A session. So, ma'am, the first question is, COVID-19 have impacted everyone, but especially laborers. Many states even went a step ahead and suspended labor laws. Does the code have any provision which will help laborers to safeguard their rights if state suspends the labor laws?
So as I said, the labor laws is a concurrent list. So the states can modify it depending on their state. Now these codes are actually the central codes. So the states have to modify their state laws in accordance with the code. They cannot contradict each other. So as I said, most of the provisions under the code have delegated powers to the central and state. That's one. Second is they have left many aspects of the rights of workers. Say, for example, under COVID, okay, what are the rights that workers have? Everything is left vague. There's no provision with regard to how workers can implement that. So say, for example, health and safety, there's no provision. As far as working hours are concerned, as I said, the states are given powers to even increase working hours. Then if you look at the social security, the social security is the most important part of workers being affected during the COVID, because we have gone to the Supreme Court, where we have said that the workers, unorganized workers, even under the earlier acts, the Social Security Act and the Construction Workers Act, provided for certain schemes under that act. But workers can't access those schemes because they're not able to get themselves registered. And the government has started a registration process online, which is extremely difficult for workers to register. And therefore, large number of workers have been left out of the earlier schemes also. So now, with regard to this present code, how do we ensure that large number of workers are covered, particularly where there is a provision for registration of workers, and if the workers are not being registered? So these are some problematic aspects, and we have gone to the Supreme Court not challenging it because it has not yet been notified. The problem with these codes is that we can't challenge them because they are not yet notified, particularly since rules have not been framed. Each state has to frame their own rules. Many of the states have not framed the rules. So they cannot, so it's only particular sections which are being notified. One section is a section which says that the earlier acts are not repealed. They will continue to exist till this comes into place. And the second provision is that meanwhile, while the rules are being framed, the registration of workers should be started. And that registration should be completed within a particular period of time. So we've gone to the Supreme Court saying that this registration has to be simplified so that large number of workers are covered.
Precisely, ma'am, precisely. Ma'am, the next question is, what difference labor code will make to the current labor situation in India?
It's a disaster, I mean, to put it mildly, because the Employers Association and various other state governments have supported the codes and have encouraged the notification of these codes on the ground that it will ease the business, ease the business in terms of employers being able to carry out their businesses in a smooth fashion without any interference or without any interruption from the workers, or being restricted by various laws. Like, for example, I didn't cover that, but for example, the retrenchment, closure, etc., where earlier the laws provided a ceiling of 100 workers. If there were more than 100 workers, you have to follow certain procedure. Under this code, if you have more than 300 workers, only then you have to follow those procedure. So the employers are supporting this, saying that it will allow them to hire and fire workers. But if we look at what is happening in Rajasthan or in other states, where those states who have introduced similar laws, we will find that there has been no ease in carrying out any business. The situation is even worse. For example, in Rajasthan, there has been no growth in terms of industries being able to operate in a free and open fashion. So this false narrative that is being given, that if these laws go, there'll be easier ways of carrying out business. The employers will be able, but we should also remember that unlike other countries which have a security net, our country does not even have that. We don't have any security net which is promoted by the government. It is basically based on employer-based benefits which are given. So with no security blanket to support you, and with the employers throwing you out, where is the demand that is going to come from the workers if you don't have any money? In fact, the Confederation of Industries has come up with a statement saying that the central government should print more money. They should print money so that you have money available and people can buy. So if you don't have wages, you don't have any money to purchase goods, how is the economy going to benefit?
It's quite an observation, ma'am. Ma'am, associated question with this, with the last question is, it has been said that the 4 labor codes also take into consideration the concerns of the contract workers as also the gig economy. Ma'am, what are your observations on the same?
Yeah, that's a good point. I did not cover gig actually. That is the positive aspect of the Social Security Code, because it covers gig and platform workers, which was not covered earlier. They were basically categorized under unorganized workers under the Social Security. So here you have. But again, the problem is, as I said, one, how do you register these workers? How do you make the aggregator responsible for the workers? And 2 is there are no schemes. Those schemes are going to be subsequently framed. So what are these schemes? How will it reach those workers? That's one. Another major problem. As far as contract workers are concerned, it's a major problem which I have not been able to cover, and that is that the earlier act, the Contract Labor Act, provided for certain benefits under the Contract Labor Act. One was that their service conditions should be, if they're working in a factory where permanent workers are doing similar work, then their wages or other benefits should not be less than the permanent workers' benefits. That's one provision in the contract which is retained in the code also. But the most important part was that if workers were working as contract workers for a long period of time, then they should be made permanent after following the procedure under the Contract Labor Act. Here they have introduced a new concept known as core industry. What the code says is that contract workers cannot be employed in core industries. Now, a core industry can be, say, for example, it's a steel factory manufacturing steel. But to manufacture the steel, you might need to have sweepers. You will have catering facilities for the workers. You have gardening for the outside factory area, and so on and so forth. So the code specifically says that's gardening, housekeeping, watch and ward, etc., will not form part of core industries, which means that only contract workers can be engaged. So even if it's of a permanent and perennial nature, which was the definition in the Contract Labor Act, still those workers can continue as contract workers. They cannot claim to be permanent workers because they are not working in the core industry. So here, again, you are actually increasing the casualization of permanent workers by encouraging contract workers in more and more sectors, which was not allowed earlier.
Yes, ma'am. We have some questions which are especially pertaining to the collective bargaining capacity of the workers and the workers' union, especially in the backdrop of this code, ma'am. Ma'am, the question is, how effective will these amendments be in order to safeguard the voices of laborers and the unions with regard to different difficulties they face at the workplace?
Didn't get it. Meaning, how will the code be implemented? Sorry, I didn't get the question.
How effective will these amendments be in order to safeguard the voices of laborers and the unions with regards to different difficulties they face at the workplace?
Yeah. So, I don't think I should repeat myself, but I think I tried to cover the problems that they face, because you have absolutely no mechanism by which workers can raise these demands directly in terms of whatever problems that they face. So you have, everything is so nebulous in the sense that the schemes are not clear. The state government and central government is given full power to do what they want. They can change the law, they can change everything. So the organizations that are set up under the code are also absolutely vague in terms of what rights the workers would have. So I'm unable to answer it in a very specific manner, because the acts are really not helpful in solving the present problems in terms of many issues.
Yes, precisely. We are getting more and more questions, but I guess we have just space for one more question, ma'am. Ma'am, how can the workers of the unorganized sector and small-scale industries be benefited on a larger scale through these amendments?
If we look at the Minimum Wages Act, which is the most basic act in terms of affecting a large number of unorganized workers, it's really an empty shell, because, as I said, there is no formulation of the national minimum wage yet decided, which forms the basis of the wages code. So how are the workers going to implement unless the Minimum Wages Act, which will be implemented till this notification takes place and the code comes into being? But the code will not become effective till at least 3 years, because the committee that has been set up to decide precisely this point will not come up with a report for 3 years. So for 3 years, there'll be a total vacuum with regard to payment of minimum wages. Then when you come to ESI benefits, those benefits are going to go only to the organized workers, which was the situation earlier. But those acts were not being implemented because there were problems with regard to the enforcement machinery. So instead of enforcing the powers of the government authorities, they've just left it to the whims and fancies of the employers. So basically, even the employers have been given total leeway. In fact, I wanted to add that part that as far as the penalty is concerned, the earlier acts had some penalty. Now, the acts totally decriminalize. Say, for example, if wages are not paid, it decriminalizes the offense by saying that it can be compounded. So if an employer is not paying the wages and the inspector goes and says that, okay, these wages have to be paid, he'll say, okay, forgive me this time, I will pay it and will not, not breach the law again. So that those offenses can be compounded. The inspector can make a report saying that he should not be prosecuted. So things of this nature with regard to implementation itself is so hazy and in favor of the employer that the workers have absolutely no standing with regard to any complaints that they make before the authorities.
Yes, ma'am. Ma'am, a great section of our viewers have expressed their thankfulness to you in highlighting about the lack of the health provisions and regulatory provisions in these codes. And similar to that is a question which we've just got, that since there are no specific solid regulatory provisions with regards to health and safety for workers after repealing the acts, will it result in giving the employers a chance to bypass the safety steps for the employees and workers?
Yes, just one word I can say, yes, it will. And we've seen what's happened right now. I mean, they've been like, I have dealt with one factory case where near Pune, besides this other Pune factory, it was just blown, an explosion took place and the factory inspector had not visited the factory at all. And he was operating it without any safety regulations, without ensuring that the boiler was in operating condition. Nothing was done. So in the earlier acts where there are specific provisions, if they are not being implemented in this code provisions at all, how do we ensure any of this safety provisions being applicable to workers? I'm sorry for being so critical, but
Very correctly, ma'am. You have actually, in the course of this entire exposition and the extended Q&A session, madam, every point has been very, very much clarified by you, and especially this last question. With this, we come to the conclusion of the Q&A session. We shall now be moving on to the vote of thanks. At the outset, it is to my honors that I have got the opportunity to propose the vote of thanks for today's event. We would like to fondly remember our founder chancellor, Dr. Patang Rao Kadam sir, because of whose blessings this event has been a great success. We are grateful to our special guest, Honorable Senior Advocate Gayatri Singh Madam, for taking out time from her busy schedule and gracing this occasion. We would like to sincerely thank our Dean and In Charge, Principal Dr. Ujwala Bendale Madam, who by her wisdom and ingenuity continues to guide S.A.R.A.L.L in all its endeavors. Our sincere gratitude to our coordinators, Dr. Jayashree Khandare ma'am and Rahi Ahlat ma'am, who have been instrumental in the setting up of this society and remain committed to its overall objectives. A special thank you to Advocate Anirudh Kulkarni sir for his support in the group's overall functioning. Lastly, we thank all our volunteers, staff, and members of the technical team because of whom we could connect through the digital space. Finally, we thank all of you for joining us through the web space and making this event a success. Lastly, from the bottom of our hearts, we once again say thank you.
Thanks a lot.
May we request, thank you. May I request everyone to kindly switch on their cameras for a group photo, please.
Yes, thank you, ma'am. Thank you so much.
Thanks a lot.
Thank you, ma'am.